The final topic to cover are remedies. If one party breaches a contract, then the non-breaching party is entitled to enforce it. There are two basic types of remedies that courts can grant. The first and more common type are damages, that is, monetary compensation. The second type are equitable remedies. Damages are contract law's main remedy. Their purpose is to compensate the non-breaching party by giving them the benefit of their bargain. We can distinguish between different types of damages. If applicable to the specific situation, one or more of the following types of monetary damages may be claimed at the same time and in addition to one another. The first category, compensatory damages, puts the non-breaching party in the same position that it would have been in if the contract had been performed as promised by the other party. The measure of compensatory damages is the difference between the value of the contract as originally promised and the value of the contract actually received. This is often referred to as the loss in value that is being compensated for. For instance, if goods are involved, then the loss in value would be the current market price of the goods minus the original contract price. Alternatively, if a party covers, that is, it buys substitute goods because the goods it contracted for were not delivered, then the loss in value would be the cost of covering minus the original contract price. Suppose that someone buys a laptop from a computer store, but the store does not deliver the device. The damages would be equivalent to either the difference between the agreed price and the current market price of the laptop, or the difference between the agreed price and the price that the purchaser paid to buy the laptop from another dealer. A second category are incidental damages. These damages cover ordinary expenses that directly arise from the breach and that are incurred by the non-breaching party. They will be offset by any losses that were avoided by the non-breaching party. Common examples of incidental damages include additional costs of shipping, storage, and advertising that arise because a non-breaching party has to make new arrangements as a consequence of the other party's failure to perform. The final category are consequential damages. These damages pertain to special losses caused by the breach. The most common examples of consequential damages is a loss of profits. Since these damages can be potentially quite large and unexpected for the other party, they can only be claimed if they were reasonably foreseeable when the contract was made, and provided that they can be measured with reasonable certainty. This principle is illustrated in the classic English case of Hadley versus Baxendale. The plaintiff in this case was Hadley, who operated a mill that produced flour and other grain-based products. At one point, a mechanical component of the mill's steam engine broke, and Hadley arranged to have a new one made. However, the engineering business that agreed to make the new crankshaft required that the broken one be sent to them in order to ensure that the new one would fit properly. Hadley therefore contracted with another business, represented by Baxendale, to deliver the crankshaft to the engineers by a certain date in order to enable the work on the new crankshaft. However, Baxendale failed to deliver in a timely manner, which caused a delay in making the new crankshaft, which in turn caused Hadley to lose business as he wasn't able to operate the mill without the new part. Hadley sued for the profits he lost due to Baxendale's late delivery and won in the lower court. Baxendale appealed, contending that he did not know that Hadley would suffer any particular damage by reason of the late delivery. The question raised by the appeal was whether Baxendale could be held liable for damages that the defendant was not aware would be incurred from a breach of the contract. The court held that Baxendale would not be liable for consequential damages. The court stated that Hadley's loss of profits could not reasonably be considered a consequence of the breach of contract that would have been fairly and reasonably contemplated by the parties when they entered into the contract. The general rule following from the case is still applicable today. A party is liable for all losses that the party could have reasonably foreseen, including lost profits, but not for those that the party could not have reasonably foreseen.